Hello students, your topic for today is Rajasthan Rent Control Act 2001. So in this we will be covering chapter 1. So short title, extent and commencement is what is in section 1. This act may be called the Rajasthan Rent Control Act 2001 and it shall extend in the first instance to such of the municipal areas which are comprising the district headquarters in the state and which later on to such of the other municipal areas as the state government may by notification in the official gazette specify from time to time. It shall come into force with effect from such date as the state government may by notification in the official gazette appoint. So definitions. So first definition is amenities. Amenities includes the supply of water and the supply of electricity passages, staircase, natural light, lavatories, lifts, conservancy, sanitary services, telephone services, TV, cable services or the like. Then is the appellate rent tribunal. So this means the appellate rent tribunal constituted under section 19. Then comes the landlord. So landlord means any person who for the time being in receiving or if is entitled to receive the rent of any premises, whether on his own account or as an agent or as a trustee or as a guardian or as a receiver for any other person or who would so receive or be entitled to receive the rent. If the premises were let to a tenant, then is the lease. So lease means a lease as defined under Transfer of Property Act 1882. Then comes municipal area. So municipal area means the municipal areas as defined under Rajasthan Municipalities Act. Then is premises. So the meaning of premises is that any land not being used for agricultural purposes. Then second is any building or part of building that is let or intended to be let for the use or as residence or for commercial use or for any other purpose that includes gardens, grounds, godowns, garages, outhouses, if any that is appurtenant to such building or part, or which includes any furniture supplied by the landlord for the use in such building or part. Okay, it also includes any fitting affixed to and amenities that are provided in such buildings or part or for more beneficial enjoyment thereof, and any land appar- appertant to and let with any such building or part, but it does not include a room or other accommodation in a hotel or in a dharmshala, in a in a Saraj or in a launching house or hoarding house or hostel. Explanation for this is this that in absence of a contract to the contrary, the top of the roof shall not form part of the premises let out to a tenant. Then there is rent authority, which means officer appointed under section 22A. Then there is rent tribunal, which means rent tribunal constituted under section 13. Then there is senior citizen, which means a citizen of India who has attained the age of 65 years or more. Then there is a tenant, which means first the person by whom or whose account on behalf rent is or but for a contract express or implied, and it would be payable for any premises to his landlord, including the person who is continuing in its possession after the termination of his tenancy, otherwise than by any order or decree for eviction passed under the provisions of this act. And then tenant means in the event of death of the person referred to in subclause 1. Then in case of premises, if they are let out for residential purposes, his surviving spouse or his son or daughter or mother or father who has had been ordinarily residing with him in such premises as member of its family up to his death. that will be tenant. And in case of premises that is let out for commercial or business purposes, then his surviving spouse or son or daughter, mother or and father, who had been ordinarily carrying on business with him in such premise as member of his family up to his death. And then comes the tribunal. So tribunal means an appellate rent tribunal, uh, as the case may be. So, Chapter 2 and Chapter 3 not to apply to certain premises and tenancies. Nothing contained in Chapter 2 and Chapter 3 of this Act shall apply to first, second, and third, which are emitted. Then the fourth clause is to any premises that is belonging to or it is let out by the central government or by the state government or by a local authority. Fifth clause is to any premises that is belonging to or that is let out by any body corporate constituted by a central act or a Rajasthan act. Then sixth is to any premises that is belonging to a government company as defined under section 617 of the Companies Act 1956. Then seventh is to any premises that is belonging to the Devasthan Department of the state which are managed and controlled by the state government or to any property of a Waqf registered under the Waqf Act. Then eighth is to any premises that is belonging to any such religions, charitable or educational trust or class of such trust as may be specified by the state government by notification in the official gazette. Ninth is to any premises that is belonging to or is vested in a university established by any law for the time being in force. And last, that is tenth, is to any premises let to banks or any public sector undertaking or any corporation that is established by or under any central or state act or multinational companies and private limited companies or public limited companies having a paid up share capital of rupees 1 crore or more. Explanation to this is that for the purpose of this clause, the expression bank means the State Bank of India that is constituted under the State Bank of India Act 1955, a subsidiary bank as defined in the State Bank of India, then a corresponding new bank constituted under Section 3 of the Banking Companies Act or under Section 3 of the Banking Companies Act 1980, then any other bank being scheduled bank as defined in Clause E of Section 2 of the Reserve Bank of India Act 1934. Then 11th is to any premises that is let out to a citizen of a foreign country or to any embassy, high commission, legation or other wholly of a foreign state or such international organization as may be specified by the state government by notification in the official gazette. Then section 4 is about the rent to be as agreed. So the rent that is payable for any premises shall, subject to other provisions of this act, be such as may be agreed upon between the landlord and the tenant, and it shall not include the charges that are payable for amenities which may be agreed upon separately, and it shall be payable accordingly. Then section 5 is the payment and remittance of a rent by tenant. So unless agreed otherwise, every tenant shall pay the rent by the 15th day of the month next following the month for which the rent is payable. Then subsection 2 of this is that every tenant who makes a payment on account of rent shall be entitled to obtain a receipt of the amount that is paid duly signed by the landlord or his duly authorized agent. Subsection 3 is that a tenant may make payment to the landlord for his duty authorized agent by any of the following methods. First, by personal payment like cash or by check or by bank draft or by payment in the bank account as may be specified by the landlord or by remitting through postal money order. Fourth subsection is that the landlord shall disclose to the tenant his bank account number and the name of the bank in the same municipal area in the rent agreement or by a notice sent to him by registered post acknowledged due. That's all. Thank you.